Well, hello there. It's me, Tracy B, and you're listening to Self Represented in Family Court. Well, today I wanted to talk to you about co-visitation, parenting time, access time with your children over the holidays. So it is Christmas morning. It's 10 a.m. You're waiting impatiently for your children to be dropped off by your ex. They should have been there an hour ago. You have no texts, no phone calls, no communication whatsoever from the other party. And you're wondering, what is going on? Where are my children? Well, are you supposed to have visits? Is there a court order? Are you supposed to have visits because there's a MSA or mediated settlement agreement? Are you supposed to have visits because there's a temporary order? Are you supposed to have visits because you came to an agreement and you submitted it to the court? That matters, because if you have none of those and you just have their word that they're going to bring the children to you for your visits, for your time to spend with you on Christmas Day, then you really don't have much of a remedy. I know it stings. Ooh, it hurts. But you know what? You shouldn't have trusted them to begin with. Oh, I know you didn't go to court yet, or you filed and you didn't get before the judge yet, or you went before the judge and the judge didn't give you a temporary order, or you got a temporary order and it doesn't cover the holidays. Well, again, now you realize why when you go to court, why when you're thinking about going to court, why when you're preparing for going to court, you need to always think 10 steps ahead, because court is 20 steps behind when it comes to issuing orders, covering things that you think are important to be covered. The judge, key players are not on the same timeline as you. So you need to be thinking ahead at all times. And you might have filed, you just didn't get a court date yet. Or, like I said, you don't have a schedule yet. You have an order, it just doesn't cover these holidays. So I hate to break it to you, but you're in this as bad of a position or predicament as someone who has no order whatsoever. You know what? I'm going to take that back. You do. You are in court. You haven't gone yet, but you filed. You've gone, but it wasn't covered. Or whatever. You're in court. You've started. It started. So you do have some recourse. Not right now, unfortunately, because you can't file anything. A motion's not going to make it to a judge before the holidays start. It's not an emergency, so you can't file an emergency petition because, your children not making it to your home for the holidays is not an emergency. They're not in danger. There has to be danger to your children for their judge to actually approve. But you're in court. You're in court and you have no children on the holiday. What can you do? Well, number one, when you go to the police, because that's what you're going to do, you're not going to call the police. You're going to go to the police and you're going to file a police report. You're going to get something in writing indicating, remember, there's no court order. So the police are not going to do anything. Some of them might, but they're not obligated to. So you're going to go and file a report. You're not going to call them. You're going to go and file a report, and you're going to make sure you get a copy of the report or information as to when you should come back to pick up a copy of the report. If they don't want to do that, ask to speak to a supervisor or ask to speak to someone who will oblige you and do just that. That's number one. At the same time, you're going to communicate to the other party, the other parent, that they were supposed to have your children at your home at this time on this day, as you agreed, you discussed, as you've done in the prior years. Again, there's no court order, there's no custody order, there's no parenting plan or parenting agreement, there's no MSA, there's nothing yet. So you're going to start there. After that, you're going to pretty much try to make the best of the day, that day. Now, when you go back to court for your first appearance, mediation, whatever it is, and you're actually in the presence of the court, the judge, or an extension of the court, you're going to let them know what happened. You're going to let them know that the other parent, the other party, failed to produce your children, even though that was the agreement. There was no agreement? You didn't discuss this? That's what you're saying? Oh, well, you know what? Not much you can do. Yes, there is. You can actually still ask the other parent to bring the children to spend some time with you. Think of anything. You'll meet them somewhere. You'll split the day. You'll something. Make some sort of arrangement. Be persistent. Be amenable. You didn't discuss this before, remember? You have no court order. You have no MSA. You have no custody agreement. You have nothing. You have nothing and no discussion. You're at their mercy. Okay, so you tried that. You discussed this before. You didn't discuss this before. There's no court order. There's nothing. Now it's time to go to, what are you going to tell the judge? Well, you're going to tell the judge either you discussed this before and the other party did not make good on what you discussed, what you agreed to, and you actually were deprived of your time. You tried, you attempted to communicate with them, and nothing worked. The judge is not going to get too involved in the details of your arrangement. Most judges don't unless it's intertwined with another issue. But what it will do is let the judge know that you were able, you were willing, you were capable of attempting to communicate with the other party to resolve. That speaks mounds in family court. Letting the judge know that you are the one that attempts to resolve things without getting the court involved. You didn't have a choice because the court wasn't going to get involved. You didn't have time. Or you were civil, or you were even flexible and amenable to doing things a little unconventional because you wanted that time. You know what you've just done? You've just earned yourself a couple of brownie points. No, don't go to court saying, Judge, I didn't reach out to them because I know they were high conflict and they wouldn't have agreed anyway and it was a waste and blah, blah, blah. Don't do that. Don't do that. No, don't go to court saying, Judge, I didn't do anything. I went right to the police station, or I called the police and then the police told me this. Don't do that either. Don't do that either. Start off with, hey, Judge, I attempted to reach out to the other party. I even offered this. I even tried this. I really was trying to resolve this and get them to cooperate, and nothing worked. And that's why I went to the police station, got a police report, and here it is. And I just want to make sure that for the next major holidays, this doesn't happen again. So that's what you're going to do, right? So what's going to happen now? You think it's going to change? Well, you're going to ask for a parenting plan, a parenting agreement that's going to not only address the schedules, it's going to address what happens if the other parent does not follow the schedule. And even further, you're going to take some preemptive moves, some preemptive measures, and make sure that whatever the other party can possibly think of bringing up as a reason or an excuse or an answer or an explanation, you've already addressed that. You know the other party. I know they change. They all change. But some behavioral patterns that you can pretty much anticipate what they're capable of or what their next move might be. You need to think preemptively as far as that is concerned and address that in your new parenting plan, your parenting or custody order. So the judge doesn't want to give you an order. Oh yeah, you're going to need an order. If you're going to court in January or February, think about Memorial Day weekend. Think about spring break. Think about summer break. If you're going to court in May or June, start talking about the holidays, Thanksgiving and Christmas. Yes, because you don't know when you're going to get back before the judge. You can have a date scheduled and that date and before the holidays, and that date gets canceled and pushed back beyond the holiday. You have to always be 10 steps ahead of the court because the court is 20 steps behind. So I'm sorry you're spending the holidays alone. You don't have your children. But I can assure you that if you start thinking strategically, planning, and yes, plotting, you won't have to deal with that again. You can get the judge or the mediator or the parenting coordinator or the guardian ad litem, whoever's going to get involved with the details of your parenting agreement, to get you some, whether that be an additional holiday, an extended vacation, or additional days in the coming months, whatever that is. Nothing's going to make up for missing the exact holiday. But you can celebrate Christmas or Hanukkah or Kwanzaa any day of the year, honestly. That's what a lot of co-parenting agreements or arrangements do. They make their holidays on the days that fall on their schedule, their parenting times. So if you need to discuss anything regarding your upcoming holidays, if you want to talk about the parenting plan that you created or that you want to create or that you've proposed, if you want to talk about anything regarding strategy in your custody arrangement, your co-parenting arrangement, your divorce, we can discuss this in the strategy session where we actually pick apart your case, identify the real issues, and come up with at least 3 major moves that you can make to address those issues. Feel free to reach out to me at thedivorcesolutionist.com and I will set up a meeting with you. Take care.